G'day everyone, and welcome to the final video in week 4 of our legal ethics course. As you know, this week we're discussing a practitioner's paramount duty, their duty to the court. In the first video, we talked about this in general terms, and then in the second video, we looked at the duty of candour. In this final video, we're going to discuss the duty to keep undertakings. Many times, not just during actual court matters, but also during out-of-court work, there needs to be a bit of give and take between opposing practitioners for everyone's benefit in order to make sure things run smoothly. Sometimes that's going to involve practitioners making promises, that is, giving undertakings. So for instance, you might be in court, you might find that an affidavit that you want to rely on hasn't actually been properly filed, so it hasn't been stamped in the registry. This might be because the affidavit was only made 10 minutes before court when the need for it became apparent. Now the court could just adjourn proceedings and wait until you've gone and sorted things out in the registry, but that'll waste a lot of everyone's time. It's more likely and more sensible for you to simply say, Your Honour, I notice that this affidavit has not yet been sealed by the registry staff, and I'm happy to undertake to attend upon the registry before I leave the building today. That lets the judge proceed as though the affidavit has already been stamped. Or another example, let's say there is a matter where you're for the plaintiff and the matter settles, and so you give an undertaking to your opponent that as soon as the settlement sum is paid into your trust account, you will file a notice of discontinuance, withdrawing your client's claim. You see how it works? These promises are like the common sense glue that can hold the system together. But for any of this to work, you have to be able to take those promises to the bank. The promises have to be absolutely ironclad. You can actually be subject to professional discipline if you give an undertaking and then breach it. Solicitor's Conduct Rule 6.1 says that a solicitor who has given an undertaking in the course of legal practice, so not just in court, anywhere in the course of legal practice, must honour that undertaking and ensure the timely and effective performance of the undertaking unless released by the recipient or by a court of competent jurisdiction. Of course, what this means is that if a practitioner fails to honour an undertaking, they are not merely breaking their promise, they're also breaking one of the solicitor's conduct rules. A failure to abide by an undertaking is a failure to abide by the rules. For instance, in a matter called the Legal Services Commission against Zaghini, a matter was being transferred from one firm to another. This happens, often when the client is unhappy. It can lead to a certain amount of awkwardness between the firms. Mr. Zaghini undertook, as part of this process, to pay certain money from his firm's account to the other firm's account within 21 days. In fact, despite repeated demands, he didn't pay for 11 months. The Legal Practice Tribunal found that this was professional misconduct. There were 2 other professional charges, and in total, Mr. Zaghini was reprimanded and ordered to pay a fine of $6,000. In addition, an undertaking given in the context of court and then not delivered, it's almost like a lie to the court, and so it can constitute a contempt. So in a matter called Evenco against the CFMEU, the union undertook to the court not to interfere with Evenco's employment contracts. A union official then breached that undertaking. A finding of contempt was made, and President McMurdo of the Queensland Court of Appeal said, a failure to comply with an injunction or undertaking may not amount to contempt where genuine and reasonable attempts to comply have been made. So a failure to deliver on an undertaking can be contempt where there are not genuine and reasonable attempts to deliver. All of this obviously means that you have to be super careful when giving undertakings. Now, strictly speaking, any indication to anyone else that you'll do something could potentially be construed as an undertaking. And of course, anything that you tell the court you will do, you absolutely have to do, whether the word undertaking is used or not. Why? Because we can't ever lie to the court, not ever. However, in dealings outside the court, the formal rule is any type of promise or agreement could be construed as an undertaking, but in reality that's not likely. In reality, an undertaking is usually only given when the word is used, and it's usually only given in writing. Most firms will absolutely prohibit a new graduate lawyer, or indeed often anyone other than a principal, from giving an undertaking. And most wise firms have an undertakings register where undertakings are recorded so that their performance can be monitored. Because undertakings are typically given in writing, there's the chance to carefully consider the language of the undertaking. This needs to be done with the greatest of care, with every effort to remove every possible ambiguity and to ensure that the undertaking reflects exactly what you intend to promise, no more and no less. Ambiguous phrases like "we will make every effort" should be avoided, because what the hell do words like that actually require you to do in order to comply? Avoiding ambiguity is crucial, because if it's alleged that you have failed to deliver on the undertaking, then the undertaking will be construed by a court or tribunal, much in the same way that a contractual provision or a statutory provision might be construed. However, it will be typically construed on the basis of how the recipient could reasonably have understood the undertaking. So tricky wording is unlikely to help you. Clear, unambiguous wording of a promise that you then deliver on. That's the thing for undertakings. All of this leads us to the golden rule for undertakings. You must only ever promise to do things that are within your own control. So, for instance, it's no good giving an undertaking that your client will provide an affidavit or a payment, because if the client doesn't do that, it's you that has breached the undertaking. If you undertook, "Within the next 3 business days, we will advise our client to file an affidavit," and request that our client do so within 7 days of our request, well, that's fine, because your promise is complete when the request is made. But if you undertake that your client will file an affidavit, your career is in your client's hands. In a New Zealand case, a solicitor gave an undertaking that their client would pass clear title to a piece of land. It turned out, though, that there was an encumbrance on the land, and the solicitor had no power to compel the third party to release that encumbrance. Neither did the court. But the court was clearly unamused, describing the carelessness of the solicitor and his subsequent reticence in furnishing any explanation or excuse. The record doesn't tell us one way or another, but one imagines that the Law Society in New Zealand would have been most unamused. Now, obviously, it makes sense that if one shouldn't give an undertaking outside one's own control, then we shouldn't be asking opponents for those sorts of undertakings either. And the solicitor's conduct rules reflect this. Rule 6.2 says, a solicitor must not seek undertakings that would require the cooperation of a third party who is not a party to the undertaking. So let's summarise. Undertakings are a special, important type of promise. They go along with the duty of candour. The duty of candour says that lawyers must not lie. The duty to fulfil undertakings says that lawyers' promises must be solid gold. This means that if you give an undertaking, you should do it in writing, and in the clearest, most unambiguous terms possible. You must make sure that the promise is absolutely within your capacity to deliver, and then finally, you must deliver. You must. Your reputation and your career depend on it. This brings us to the end of week 4, folks. This week, we've looked at your paramount ethical duty, your duty to the court. We've looked at just why this is the paramount duty, and we've looked at the 2 most important specific instances of the duty of candour and the duty to honour undertakings. I want to finish by reminding you, though, that ethics is not about rules. Ethics is about more than just rules. Being an officer of the court, being a minister of justice within one of the most effective legal systems that history has ever produced, means that your duty to the court has to soak down to your very bones. When you give your oath and sign the roll, you become an officer of the court, assisting the court to do justice by representing your client as well as you can within the rules is how you make the world a better place. It matters. Next week, we look at how you do represent your client by examining the ethical ramifications of your duty to your client. See you next week.